And hello, everybody. It's Wendy Sellers, the HR lady. We're not dealing with the most fun topic today, but if done right, terminations can be very respectful and they can help the individual who is leaving go on to a greener pasture that is going to fit their knowledge, skills, and abilities. And so, number one, like I mentioned, we want to make sure we're following the law. We want to first of all, rule out any kind of discrimination. And so if a supervisor, a manager, a director is coming to you and say, hey, Wendy's got to go, she's got to be off my team, we need to, first of all, get into a private room and have this private conversation. This should be a management only conversation. We should not be bringing into this conversation, anything about, what coworkers feel or anything like that. Do we want to take coworkers' feelings and facts into consideration? Absolutely. But these conversations need to be on the management level and not be discussed on the floor, so to speak. Regarding federal laws, again, I mentioned previously that they're depending on where you are in the United States, we all have to follow the federal laws. I don't care what, industry you're in, if you're for-profit, non-for-profit, government, there are federal laws that we all have to follow. We have to then make sure that we're also following the state laws too. And the state laws, again, can be super complicated. So I'm sure you've heard of the Equal Employment Opportunity Commission. It's usually abbreviated EEOC. It's a federal organization that regulates federal laws, and it prohibits employers and their workers, including unions, if you have any unions, if you're dealing with any kind of staffing agencies. If you have more than 15 employees, you are going to have to comply with the EEOC. For age discrimination specifically, it's 20 employees or more, but you have to make sure that you are teaching yourself and all your management members about harassment, discrimination, and retaliation. So moving on here, let's talk a little bit more about, tangible employment actions. You may have heard these words before, but an employment action, including termination, must result in a tangible employment action that is a change in employment status or the privileges of employment. And the basis for doing so must be due to the employee's protected status. And so this is a lot of words for saying, listen, discrimination based on somebody's protected status is illegal, period. But it's also costly and disrespectful. So what is a protected status? I'm glad you asked. First of all, I'm going to go back a few slides. It's all of these things down here in the second part of this slide that I've already mentioned, but then it could be more depending on your state. Your city might even have stuff, or your county or your industry might have stuff, so it can get super complicated. But other things are shown here on the screen as well. It could be things such as marital status. Again, you have to look at the laws all the way down to your zip code or where your employee zip code is, especially if you're dealing with remote workers. Marital status, parenthood, domestic partnerships, victims of domestic violence, smoking or tobacco use, even use of medical marijuana is something that could be protected. Remember that you need to be following the law or you are going to pay the consequences, which is two things: money, and then it's going to be all over the news too, and then probably all over one of my future presentations. Having this point person, even if it's an external point person for consistency, is so super important. And I want to also say, you really should be going above and beyond the law. You should be saying, here's the law in our country, here's the law in our state, here's the standard practices in our industry. But I want to go above and beyond that because I want to be an employer of choice. Show respect when you are considering termination, or if you've already have considered termination and you're saying we're going to go forward with that. We don't want to ever retaliate against somebody by terminating them because they haven't, they're complaining about a manager, they're complaining about a coworker, they're filing a case of discrimination or harassment or bullying. We don't want to retaliate. So a manager may not fire, demote, harass, or otherwise retaliate against an individual for filing a complaint of discrimination, participating in a discrimination proceeding, or otherwise opposing discrimination. This is from the EEOC. This isn't from my brain. This is directly the law.